today, but I'm here to introduce Mr. Bob Bennett. Mr. Bennett served as general counsel for Coca-Cola Bottling Company in Guatemala, neighboring country, my home country, and he has served clients throughout Texas and many parts of the United States in civil and criminal matters. We're very lucky to have him today because we get to plug in 1 hour of ethics, which are few and far between up in our area. And so let me welcome you, Mr. Bennett. If you can tell us a little bit more about yourself, we'll let you get going.
I will, thank you.
For coming.
Okay, so what we're dealing with, and the thing that is the major topic for today, is this new State Bar of Texas sunset legislation. So in the last legislative session, the bar came up for sunsetting. And you know what that means is that technically if they don't renew it, we don't have a bar. And so there was a lot of people hustling around to try to make sure that we did not get sunsetted. And as part of that sunset legislation to renew it, there were certain provisions, laws, regulations that went into effect September 15th of last year. And the biggest one of those is giving certain powers and the ability of the Office of Chief Disciplinary Counsel, which is the prosecutorial part of the State Bar of Texas. They represent what's called the Commission for Lawyer Discipline, which actually brings the petition, but the prosecutor, if you have a grievance, is the Office of Chief Disciplinary Counsel. This friend of mine, Tom Watkins, who was on the commission, says that every new attorney licensed after 1999 got a new attorney to be, right? And will have at least 2 disciplinary complaints filed against them during their career. And also it's important to know that this disciplinary system that we have is one of the more complicated ones in the United States. When you look at the other states and how they do it, some states do not have mandatory bars. We have a mandatory bar. Biggest change, as far as my practice is concerned, is this Office of Chief Disciplinary Counsel Settlement Authority, in which once a complaint goes through, they can settle this at any time and not have to wait for approval from the commission if everybody agrees to it. So that's kind of a big deal because traditionally the Office of Chief Disciplinary Counsel wanted to simply wait until they did discovery, wanted to find through depositions, kind of stretch it out as far as I'm concerned. And now we can settle cases a lot earlier, which I think is good for the attorney. We're also going to have this what's called the Ombudsman for Attorney Discipline. We've never had an ombudsman before, and this person is going to have a separate office, whoever this person is. And the downside of that, are they going to be sensitive to attorneys and people who are practicing law and trying to make a living and understand the ins and outs? Are they simply going to help process complaints and try to get as many complaints filed? We don't know. It's just kind of, to me, a little bit of a scary thought that somebody's going to sit up there and really try to get as many complaints processed through their office as possible. And what are they going to accomplish and how they're going to do it? But this is going to be part of the new legislation. There's going to be a new requirement that hopefully will not affect anybody here on attorney self-reporting. So that if you have a disciplinary action in Florida or a disciplinary action somewhere else, the requirement is now that you will have to report that to Texas. Prior to that, there wasn't a requirement for that. And also, there's going to be more emphasis on what's called the National Lawyer Data Bank to maintain a record on any type of disciplinary action or criminal action. Who are tech savvy, this is a big deal, not really, that the Office of Chief Disciplinary Counsel may hold investigatory and disciplinary hearings by teleconference if all parties agree to it. And that's a change that we'll see. Prior to this, we didn't have a requirement for all attorneys to be fingerprinted, and now no matter what, where you are, as far as becoming a new attorney, you're going to have to be fingerprinted. That is the overall view of where we are with the new legislation and how that may impact the handling of grievances. Hopefully none of you will ever be faced with that, but that's kind of our system as it's going to come out at least in March of this year. Now, what I want to spend time on